Hi, this is your girl, Texas Black Diamond, and thank you for tuning in to Texas Black Diamond Entertainment. And we are talking about all the stuff that's popping up in the last couple of weeks, days. We're going to continue to pray for Robert as well. We will be talking about some sex information. We're going to talk about violations of Robert's rights. We're going to talk about holding back evidence and things like that. So please enjoy this video. Don't forget to like, share, and subscribe. Thanks again for tuning in to Texas Black Diamond, and please leave a comment down below.
Named after Brady v. Maryland, 373 U.S. 83, 1963. Requires prosecutors to disclose materially exculpatory evidence in the government's possession to the defense. Of Brady material or evidence the prosecutor is required to disclose under this rule includes any evidence favorable to the accused, evidence that goes towards negating a defendant's guilt, that would reduce a defendant's potential sentence, or evidence going to the credibility of a witness. If the prosecution does not disclose material exculpatory evidence under this rule, and prejudice has ensued, the evidence will be suppressed. The evidence will be suppressed regardless of whether the prosecutor knew the evidence was in his or her possession, or whether or not the prosecutor intentionally or inadvertently withheld the evidence from the defense. Further, in cases subsequent to Brady, the Supreme Court has eliminated the requirement for a defendant to have requested a favorable information, stating that the prosecution has a constitutional duty to disclose, that is triggered by the potential impact of favorable but undisclosed evidence. See Kiles v. Whitley 514 U.S. 419, 434, 1955, United States. V. Bagley, 473 U.S. 667, 1985. The defendant bears the burden to prove that the undisclosed evidence was both material and favorable. In other words, the defendant must prove that there is a reasonable probability that the outcome of the trial would have been different had the evidence been disclosed by the prosecutor. See Kiles, 514 U.S. at 433, 1955. Bagels and Kiles Court further defined the materiality standard, outlining the four aspects of materiality. First, the reasonable probability of a different result is not a question of whether the defendant would more likely than not have received a different verdict with the evidence, but whether the government's evidentiary suppression undermines the confidence in the outcome of the trial. The second aspect is that it is not a sufficiency of evidence test, and the defendant only has to show that the favorable evidence could reasonably be taken to put the whole case in such a different light as to undermine the confidence in the verdict. Third aspect is that there is no need for a harmless error review, because a Brady violation, by definition, could not be treated as a harmless error. Fourth and final aspect of materiality the Kiles Court stressed was that the suppressed evidence must be considered collective, not item by item, looking at the cumulative effect to determine whether a reasonable probability is reached. See Kiles, 514 U.S. at 433 to 438. Accused of a crime is normally entitled to certain kinds of evidence and information. In general, a defendant has a right to receive this kind of material, called discovery, before trial. But the prosecution's duty to hand over discovery is usually ongoing. It doesn't end merely because a trial has begun. Types of discovery. A police report is a common example of discovery. However, the law might not require disclosure of police reports in all states. A typical one will contain the names of any victims or witnesses, reports of statements by such people, observations by the officer, and more. The police report is sometimes the first item of discovery that a defense attorney receives. Other forms of discovery include, but certainly aren't limited to: 1. Recordings of police interviews of victims, witnesses, and defendants. 2. Photographs of alleged crime scenes and the people involved in the events in question, and 3. Records, for instance, police personnel records, medical records relating to injuries, and witnesses' criminal records. The right to discovery, Brady material. Courts have held that the U.S. Constitution doesn't impose a general duty on the prosecution to disclose material evidence to the defense. Material is generally shorthand for relevant. It's often used to refer to evidence that, if disclosed, could affect the outcome of a case. Exculpatory evidence. The Constitution does, however, require that the prosecution disclose to the defense exculpatory evidence within its possession or control. Exculpatory generally means evidence that tends to contradict the defendant's supposed guilt or that supports lesser punishment. The evidence doesn't have to strongly indicate innocence in the way that an alibi, for example, would. It's generally enough that the evidence provides significant aid to the defendant's case. So, information that affects the credibility of a critical prosecution witness, like the fact that the prosecution offered its witness leniency in exchange for testimony, is among the kinds of evidence prosecutors have disclosed. Giglio v. United States, 405 U.S. 150, 1972. Defense attorneys routinely submit requests for discovery, and they make sure to ask for the above evidence, which often goes by Brady material. The government violates the law by not turning over this kind evidence, even if the failure to disclose wasn't intentional or was beyond the prosecution's control. Brady violations. If the defense learns about a Brady violation after the defendant has been convicted, the defendant is typically owed a new trial if the non-disclosure was material. According to the U.S. Supreme Court, the missing evidence is to be considered as a whole rather than piece by piece, but it's material only if there's a reasonable probability that, had the evidence been disclosed to the defense, the result of the proceeding would have been different. United States v. Bagley, 473 U.S. 667, 1985, Kiles v. Whitley, 514 U.S. 419, 1995. Courts have tended to be quicker to find Brady violations where the defense has specifically requested an item and the prosecution has misled the defense about its existence. Courts will find Brady violations in other circumstances too, as when the defense has made a very general request for exculpatory material or hasn't made any request. But they might be slower to hold that the omission was material in these kinds of situations. Federal and state discovery statutes. Brady and the cases related to it provide what's essentially a baseline for what prosecutors have to turn over to the defense. The federal system and many states have statutes that entitle the defense to more material. Sometimes the defense must request this material. Federal and state statutes often require disclosure of items like the following. 1. Statements by the defendant and any co-defendants. 2. Documents and tangible objects the prosecution will use at trial. 3. A list of the witnesses the prosecution plans to have testify at trial, and perhaps prior statements by those witnesses. 4. Copies of reports of scientific tests and medical and physical examinations that have been prepared for the prosecution. Here's an example of a discovery law from California. Questions for your attorney. 1. What are the procedures for obtaining discovery in my case? 2. How does the defense get discovery from a third party, someone or some entity other than the prosecution? 3. When in the proceedings does the prosecution have to provide discovery? 4. What happens when evidence that should be disclosed is lost or destroyed? 5. Does anything else, like ethics rules or the state constitution, require that the prosecution disclose more material? 6. Are depositions allowed in my jurisdiction? 7. What remedies are available in my jurisdiction if the prosecution violates its discovery duties? 8. What kind of discovery does the defense have to provide the prosecution? Of rights. The U.S. Constitution Bill of Rights, under the Sixth Amendment, guarantees the right to a speedy trial with an impartial jury for criminal defendants in federal courts. The 14th Amendment's Due Process Clause extends these rights to state courts. While the Constitution expressly outlines the right to a jury trial, it doesn't explicitly include the right to a fair trial. However, in guaranteeing other trial rights, the Constitution provides the safeguards for a fair trial. Such rights include 1. The right to an impartial jury. 2. The right to due process of law. 3. The right to confront, call witnesses, and 4. The right to legal counsel. When any of these rights are violated, it can lead to the determination that a trial was unfair and can result in the reversal of a verdict or the granting of a new trial. Meaning of impartial jury. A criminal defendant is entitled to have a trial with an impartial jury of their peers. The specific meaning of impartial jury isn't defined in the Constitution. Rather, it was established via tradition and case law and has evolved over time. Generally, it refers to jurors not having a stake in the outcome of the case and not approaching the case with any bias against the defendant. Part of the impartiality of jurors has also been tied to having 12 jurors, although the Supreme Court suggests that this specific number is a historical accident and less of a strict requirement. However, because of the tradition and reliability of having a jury of 12, it certainly contributes to the appearance of fairness in a criminal. Between media and the judicial system can also factor into a jury's impartiality. While a media presence in courtrooms can threaten judicial fairness in general, it can have an especially troublesome impact on securing a jury who doesn't have a bias or prejudice against a defendant shaped by media reporting. The right to due process of law. The right to due process prevents the government from arbitrarily infringing on an individual's rights without some type of formal procedure. This is a broad area because due process includes many different rights and requires the government to respect the legal rights that the defendant is owed. In the context of criminal trials, the Supreme Court has found that a denial of due process occurs when there's an absence of fairness such that it fatally inflicts the trial. For example, when the accused is compelled to appear before the jury clothed in prison garb because the appearance in that attire might damage the accused's presumption of innocence with the jurors. The right to confront and call witnesses. The U.S. Constitution gives criminal defendants the right to confront their witnesses and cross-examine them, but it also gives them the right to present evidence and call witnesses who support their case. Sometimes there's a conflict between infringing on the rights of the accused and following the rules of evidence or trial procedure. For example, a defendant may be denied the ability to present testimony of witnesses about matters that were revealed out of court on hearsay grounds, but the Supreme Court ruled that this could constitute a denial of the defendant's rights. The right to legal counsel. Anyone facing criminal charges has the right to legal counsel. This means that they can contact an attorney to find out about their rights and to have the attorney represent their legal interests. Not only does the defendant have a right to have an attorney, but also the right to an adequate defense. An attorney can fail in their duties by not providing representation that is sufficient to ensure a fair trial, like failing to present exculpatory evidence or being under the influence during trial. R. Kelly evidence demand. The music superstar wants agents' notes and any evidence which is favorable. But prosecutors are pushing back. Page filing Monday, federal prosecutors fought against efforts by performer R. Kelly to obtain new information about the evidence the government intends to use against him. Kelly faces multiple counts of state and federal sexual misconduct charges in Illinois, Minnesota, and New York, ranging from sexual assault to allegations the music superstar headed a racketeering aimed at supplying him with women. Kelly had demanded a court order seeking the investigative notes of agents, complaints against those agents, and production of so-called Brady material, or evidence which is favorable to his defense. The county trial will begin with charges involving his hairdresser, Pros. But prosecutors say they are already preserving the agent's notes, that they have already provided Kelly's defense with some so-called Brady evidence, and have given assurances that they will provide more if it is discovered. They also noted they are not in a position to provide information on weakness in witness testimony, because they do not know which witnesses will eventually be called. The government does not anticipate that the trial will involve the testimony of many law enforcement witnesses, the prosecutors wrote. Most of the government's witnesses will be victims and witnesses with first-hand knowledge of the defendant's crimes. Kelly had also asked for the records of any assistance, financial or otherwise, which had been provided to potential witnesses. But prosecutors said they knew of no such assistance, save for unnamed benefits which had been provided to 2 witnesses by the Cook County State's Attorney's Office. R. Kelly's lawyer says Brooklyn federal prosecutors should drop some of their sex crimes charges against singer, because a state law prohibiting people with sexually transmitted diseases from having intercourse is unconstitutional. In a motion filed in Brooklyn federal court Monday, Kelly's lawyer argues for dismissal of several counts against the singer that are based on a New York law that says it is a criminal offense for someone who knows they have an infectious venereal disease to have hookup with another person. Steve Greenberg, Kelly's lawyer, argues that the New York law, which has been on the books since 1943, is an invasion of privacy that makes it illegal to have private, consensual sexual intercourse. This statute is facially unconstitutional. It prohibits sexual intercourse by anybody who has an STD. The definition is vast, ranging from HIV to yeast infections. It includes HPV and scabies, Greenberg writes. The only requirement is that the individual knows that they have the venereal disease. In other words, it prohibits 2 consenting adults from having sexual intercourse if either, or both, know that they have an infectious venereal disease, he continues. It does not require that the disease be passed on, nor does it allow the consenting adults to have sexual intercourse if the venereal disease is disclosed beforehand. It does not permit the use of a condom, or account for modern-day suppression drugs. Faith Rogers, one of Kelly's alleged victims, claims in a Manhattan lawsuit that the "I Believe I Can Fly" singer gave her genital herpes without informing her that he was carrying the disease. Rogers' accusations have formed the basis for some of the charges Kelly faces in Brooklyn, which includes racketeering, sexual exploitation of minors and transporting females across state lines for the purposes of having sex. Kelly, 53, has denied having genital herpes, but prosecutors allege in court records that his medical records show that he had an infectious venereal disease during the time that he was having sex with Rogers. That law dates to 1943, and was intended to prevent the spread of syphilis and gonorrhea to members of the military during World War II, according to a 2017 memo from the New York State Department of Health. The department believes the statute does not apply to people who know they are infected and reveal that information to their sex partners, the memo states. According to that law, one's disclosure that she has an STD is not enough, consent by one's partner is not enough, and well-recognized protective steps are not enough, Kelly's filing states. The law, as written, requires that one who has an STD engage in complete abstinence. That is not and cannot be constitutional. The federal charges do not reveal the names of Kelly's accusers.
Dental dams are thin, square pieces of latex that are placed over the vulva or anus during oral sex. You can also pick dental dams from a wide variety of different colors and flavors. There are 3 great reasons why you should use dental dams during oral sex. First, dental dams are your best defense against STIs during oral sex, especially against herpes and HPV, which are the 2 most likely STIs to be transmitted during oral sex. Second, dental dams can be used with lube containing water or silicone. Using lube on the side of the dental dam touching the vulva or anus is a great way to increase sensitivity during oral sex. Never use oil-based lube with dental dams, though. Oils can break down dental dams and leave you and your partner prone to STIs. Third, many feel uncomfortable or insecure during oral sex. The smell, taste, and feel of giving or receiving oral sex can make some folks feel self-conscious about their own or their partner's bodies. Dental dams are a great barrier from the hair, taste, and smell of a vulva or anus, and therefore can make folks feel more comfortable during sex. To use a dental dam. First, check the packaging to make sure the dental dam isn't torn or expired. Then, open the package carefully. Dental dams are sometimes coated with some powder to prevent them from sticking to the wrapper, so feel free to rinse it off with water if you'd like, but it's not necessary. Now you can apply water-based or silicone-based lube to one side of the dental dam. Adding lube will increase sensations for your partner during oral sex and help hold the dam in place. Next, place the dental dam on the vulva or anus before oral sex. You or your partner can hold the dam in place, and then you're ready to go. Remember to never flip dental dams during oral sex. Only use one side of a dental dam to prevent the spread of bodily fluids and possible STIs. You also should never reuse dental dams on different body parts, since you may also expose your partners to other bodily fluids and possible STIs. You can also make your own dental dams. Latex gloves, internal condoms, and external condoms can be used to make a DIY dental dam. For example, here's how you do it with an external condom. First, check the packaging of the condom for any tears and check the expiration date. Take the condom out of the packaging. Pinch the tip of the condom. Next, take a pair of scissors and cut the tip of the condom. Afterwards, make a second cut from the bottom to the top of the condom. Finally, unroll it to reveal your very own dental dam. Don't have any condoms or gloves on hand? You can use Saran wrap as a cheap alternative to make dental dams. Saran wrap can also transfer body heat more than latex dental dams, so some people feel increased pleasure when using Saran wrap. Note that you can only use lube containing water and silicone with Saran wrap dental dams.
Do we have a law now where it's saying that we are responsible for others' bodies, others' health? Are we? And I say this because when you're playing Russian roulette with your body, that's you putting a bullet in a gun. And you're clicking it, and you're clicking it, and you're clicking it, and it's like you're taking a chance with your life, okay? So, what I'm saying here, sex. Whenever a person has sex, and then they're having sex with multiple partners, it is on you yourself to make sure that you are doing it the way that's safer for you. It is your responsibility to say, okay, we're going to use a condom. It is your job, especially as a female. I'm talking about males as well, but females, they sell so many different type of condoms that they're condoms with panties, and you can put those panties on and it protect your whole vagina. You insert the condom up in you. Okay, they have that. Okay, also oral sex, they have protection for oral sex. If you're gonna do oral sex, they have protection for that as well. So how you protect yourself is on you. Don't leave it to the individual that you're gonna have intercourse with. It's you. If that individual tell you, well, I can't use condoms, I'm allergic to condoms, they itch, I have sensitive skin, I can't feel anything. You know, they make so many different type of condoms. Always be prepared. Okay? And we have to get out of this my world type thing, and everything has to go my way, into my world, into my address. How you conduct your home and your address, that's on you. But when you're a person that's free-spirited to be with multiple partners, that's your sexual fantasies. That's you, okay? We as, individuals, we can't make a person live the way that we live. We can't make a person okay, you're supposed to have one person and that's it. A lot of people want to deal with just one person. They don't want to share, and that's them. But when a person step into a relationship or a nage trois, whatever, and they know the situation, knowing multiple partners are involved here, and you don't protect yourself, that is your problem and your responsibility. And I'm sorry, I do not feel sorry for that. Also, even with the females, it's sad that DJ Kid did that to them, but also using common sense and using your head. I'm not in a relationship with this person. It's gonna be a one night stand. I'm gonna have sex with this person, but I better use protection. Okay, so that's in itself is your responsibility. So I'm not going to sit here and blame that second person. If I choose to lay down with a guy and I don't protect myself, that will be on me. I'm playing Russian roulette with my body. Okay? And at the same time, it's just like with women. It is our job, nobody else's job, to go get your mammogram, your yearly checkups, physical, get everything checked out inside and out for your body. That is your responsibility. That's nobody else's responsibility. Hold your own self accountable for your actions and what you do. It's your responsibility to protect your health and your body, nobody else. I want everybody to see how Robert's constitutional rights are being violated in so many different ways. We have the prosecutors intentionally withholding evidence from the defense prosecutors. They have, that's their duty, constitutional duty, to disclose that information, and they're infringement on his rights, on Robert's rights, you guys. The prosecutors holding evidence, and they claim they will not know the witnesses or what witnesses they're going to call. They don't know this, they don't know that. And what they're trying to do is put a pause on information for cross-examination for the defense. When it's time to cross-examine their witnesses, the prosecutors' witnesses, they don't want them to try to get up as much information as possible on these people. Prosecutors they have to give the defense everything that they're asking for. If Greenberg needs background check on these people, that's going to be the witness, the accusers, alleged accusers, and all that, they have to do that. Okay, so if you pay attention, they're withholding names until 2 weeks before the trial. Okay, they don't want to give information on witnesses. They claiming that they don't know if these witnesses are efficient enough for them. But at the same time, it doesn't matter if their name is on that list to be a potential witness or whatever the case might be, or most definitely a witness. That information should go over to Greenberg and his team, Robert's team, okay? Because they need to get their things together, all the information together. They have every right to know that person's intentions. They need doctor evidence if there's doctors evidence. They need police records. They need recordings and things like that. Statements and so forth. You know what I'm saying? Anything and everything that the prosecutor has by law, it's their constitutional duty to pass it along, all evidence, to the defense team, okay? So they can prepare to fight for their client. And so what you see here, if the prosecutors feel like that their evidence is A1, on the money, we got him, we can show that this is true, they wouldn't go through the things that they're going through. They're holding witnesses. They're holding evidence. They want to frame Robert, and I still feel to this day that the state, the prosecutors, the feds, federal, whoever, I feel that they were the ones that framed Robert with the letter and the cell phone. Like Robert knew not to take the letter and things like that. Like they told him, oh, you can't use this phone, but I'm gonna let you use it. I feel like that was a setup. So they can have a reason to hold back the name of the Jane Doe, I think 1 or 2, or Jane Doe 2 or 3, whatever the hell. The damn Jane Does. The Lidos. Okay? I'm going to call them Lidos. Okay? And with this disease, they talking herpes. But they didn't state herpes. They said infectional disease. Okay? But it could have been a bladder infection. It could have been a yeast infection. You didn't say herpes. Okay? And then for one, you tell me why one claimed to have herpes, and all these women that y'all claiming that he laid up with and been with, and these other women's claiming that he slept with them, they don't have herpes. They saying they was forced to do oral sex. You ain't got herpes in the mouth and the throat. Okay? I'm not understanding it, okay? As much as big mouth as Azraelia, she run around recording saying that Robert slept with her and Joyce slept with her, okay? If Robert slept with you and you saying that he has herpes, okay, why she's not running around saying it, okay? Why Dominique not saying that she has herpes in her baby daddy, okay? That's a question that needs to be asked. Everybody run around talking about herpes. They telling everything else. Do you have herpes? Do you have herpes? Everybody that said they slept with him. Then you have Geronda ass. She always on the script. She's gonna repeat everything somebody else say. If you pay attention to Geronda, now she got herpes. She got herpes because Faith Rogers said she got herpes. She was spit on and she got a t-shirt because Lanita Carter said she was spit on and she got a damn t-shirt. Okay? She was locked in a room because another alleged accuser said she was locked in a room. So all these people are doing is repeating and saying certain things. And this poor damn Geronda, she just needs some damn help because she's everything somebody else say. She come back and say the same damn thing. Y'all get this damn child some help because she is schizophrenic all over the place. And these are my opinions on that. The child is schizophrenic. If you pay attention to her, then she heard about a damn suicide pact. She come back on the next Surviving Lives. I was supposed to be in a suicide pact. That wasn't said until after this damn lifetime of lies came out, and then all of a sudden she was involved in a suicide pact when her ass wasn't nowhere involved in Robert's life around that time that she alleged that she was involved. Okay, it don't make any sense. I'm still looking for. I don't see no picture. I see these women taking pictures of his house, the ceiling, and everything else. I don't see them hugged up with them, pictures with him, or nothing like that. But my thing is, I'm finna get ready to get off here. I got more work to do, but I want to just try to throw that in real quick, cause like I said, every day, I wake up, a notification about Robert is popping up with some damn foolery, some damn bullshit from these damn prosecutors that claim that they got evidence that this man has created so much stuff that if you were so confident, prosecutors, attorneys, why are you going through all this stuff? Up the evidence like you're supposed to. It's your constitutional duty. It is your duty to disclose that information. Okay, that's Robert's rights. You can't be taking his rights. He's American citizen, and he deserves everything every other human being that's in America going through this system of United States law to have. Okay. So thank you guys for tuning in to Texas Black Diamond Entertainment. Please like, share, and subscribe. This was a quick video, but you get what I'm trying to say here, okay? Y'all, happy voting. Get your ass out there and vote so you can get people like Kim Fox ass out of there and all the dirty ass goddamn politicians that's working in this law system and our justice system. Get them the hell up out of there. If you want them out of there, get your ass out there and vote.